Hi, my name is Michael Burgis, and I'm the managing attorney of MB&A. I'm also a certified legal specialist in California Workers Compensation and a trial attorney. Today we're going to talk about some recent case law that has come out, and there's a case called Lopez versus General Wax. This is a workers' comp panel decision. It is not necessarily binding, but it's definitely citable and persuasive and frankly spot on with the law in my legal analysis. What happens is this: prior to 2013 and prior to the passage of something called Senate Bill 863, when an injured worker sustained a legitimate injury and had a psychiatric injury that was a compensable consequence, that could add considerable value to that case, both in terms of dire needed medical treatment to get you better, future medical treatment, and potential additional compensation for permanent disability. Now, Senate Bill 863 made some changes, and it changed the labor code, and now we have labor code 4660.1. Essentially, what this labor code says is if a psychiatric injury or a sexual dysfunction or a sleep injury is a compensable consequence of another injury, another work-related injury, usually orthopedic injuries, that psychiatric disability is no longer compensable. And there are quite a few exceptions. But what was happening here is insurance companies thought they were paying out too much money and lobbied state Congress to pass this bill because they thought too many people were complaining about psychiatric injuries. And their contention was largely these psychiatric injuries were taken into consideration on the orthopedic rating, which I disagree. That being said, we do have Labor Code 4660.1, and it does preclude psych, sleep, and sexual dysfunction permanent disability if it's a compensable consequence to another injury. There are some exceptions, okay? There's an exception for a violent act. The seminal case is called larceny, and there's a lot of cases interpreting larceny, and it looks like the main difference between what constitutes a violent act is likely coming down to whether there is a significant impact and potential loss of consciousness. But ultimately, other than a violent act, another exception is catastrophic injury. Now, the phrase catastrophic injury is very vague, very ambiguous, and that's still being litigated. But once again, if you have a psychiatric injury that's a compensable consequence of a work-related orthopedic injury, and it doesn't qualify under a violent act, and it doesn't qualify under a catastrophic injury, then theoretically, the psych permanent disability is barred. Now, a lot of defendants and a lot of workers' comp carriers take the position that, well, this case bars the injury, period. It does not. First off, medical treatment is compensable regardless of whether the permanent disability is compensable. I can't tell you how many times I hear an insurance company argue that the client's not entitled to that treatment and they cite that labor code. They simply don't know the law. That labor code is a section regarding permanent disability and compensation for permanent disability. Medical treatment is not permanent disability. And no matter what, I strongly believe that an injured worker is entitled to the future medical for those psychiatric injuries, those sleep injuries, the sexual dysfunction, if it's a compensable consequence of a legitimate industrial injury, regardless of whether the permanent disability is compensable. Now, that was a little foundation because this case deals with temporary disability benefits. And it looks like in this case, the carrier was arguing that if a psychiatrist or psychologist found that the applicant was totally temporarily disabled or partially temporarily disabled or had temporary work restrictions the employer wasn't accommodating, that would normally qualify this injured worker for temporary disability, 2/3 of their salary for up to 2 years. And here the defendant was arguing that no, because the psychiatric case was barred by 4660.1, meaning it was a compensable consequence of the orthopedic injury, that barred the benefits, all benefits, including temporary disability. That is not the case, and this case has come down, and the holding is very simple. Labor Code 4660.1 does not preclude collection of temporary disability benefits. So, if you're watching this and you're an injured worker and you have questions, and you are sustaining or you have sustained a psychiatric injury, stress, depression, anxiety, and this is a compensable consequence of your orthopedic industrial injury or some other industrial injury, you have rights. And if a defendant is telling you that you're not entitled to temporary disability, they are wrong. The case of Lopez versus General Wax is literally putting into case law that Labor Code 4660.1 does not preclude temporary disability. I'll take it a step further. Labor Code 4660.1 does not cut off medical treatment either, ever. And frankly, there are a lot of times that even if Labor Code 4660.1 purports to cut off the permanent disability, a sharp attorney can argue for your case, and if they can make an analogy that your case is a quote-unquote violent act pursuant to the Larson case and the subsequent cases interpreting the Larson case, or can argue that you have sustained a catastrophic injury, you can get past 4660.1's preclusion of stopping the permanent disability benefits. Now, once again, this is Lopez v. General Wax. Once again, temporary disability benefits are compensable regardless of whether the permanent disability is compensable. If you have any questions or concerns, please give us a call. Consultation is absolutely free, and we'll answer every question possible if it relates to California workers' compensation.